1143FY, People versus Jeremy Shaw. Ms. Brown?
Heather Brown on behalf of the people.
Stephen Lynch on behalf of the defendant via Zoom for this probable cause conference, consent to same.
All right, and Mr. Shaw, you want to state your name for the record?
Yes, sir. Jeremy Shaw.
Okay, so Mr. Shaw, prior to, you have a co-defendant in this case, and prior to you being brought into the court session, we had both attorneys present in court at the same time, and what we did was the following. Ms. Brown, the prosecutor, had indicated to the lawyers, yours, Mr. Lynch, as well as your co-defendant's attorney, that there's additional discovery that she has and will make available to your attorney, Mr. Lynch, and that may be available at the courthouse by tomorrow. So Mr. Lynch will be able to get that, review it, and then also review it with you. Second, Mr. Lynch indicated that, and the other attorney, Mr. McCarthy, indicated that the matter, they're requesting an in-person preliminary examination. So while we had both lawyers together and the prosecutor, we picked a date for that preliminary examination, and that is going to be on Friday, December the 17th at 9 o'clock in the morning. Okay.
Yes, sir.
I just wanted to advise you what took place as far as just the discovery and scheduling the court date. Nothing else transpired at that time other than Mr. Lynch, indicated that, and I knew he had done this because I have a copy of his motion. Mr. Lynch had filed a motion to modify the bond. So that's what we're going to do now with your presence. The other was simply, the bureaucratic getting all the information to your attorney so he can get that and review it with you, and scheduling the court date. Okay, so nothing else transpired outside of your presence other than scheduling the court date and making sure that you and your attorney will get all the discovery. Okay?
Okay. Yes, sir.
All right, Mr. Lynch, I think that was a pretty accurate representation of what transpired earlier.
It was, Your Honor. I just think since my client wasn't part of that, it should be noted that obviously you're standing in for Judge Gross today, that there's some question about whether her return, I'm assuming from a medical situation, is not until December, and that date had to be picked based upon not only the court schedule, Ms. Brown's schedule, Mr. McCarthy's schedule, and my schedule. So there were several dates we looked at until we settled upon that one. I just wanted my client to know that as well.
Right. I thank you, Mr. Lynch, for adding that. Right. I'm only filling in for Judge Gross, and based on some family issues there, and given the fact that there's so many witnesses in this case, there's a possibility that this exam might not be completed at one date, and so you need the continuity of the same judge to hear the case. So I'm just filling in. It could be another judge filling in another day. So it has, Mr. Lynch is correct, it has to be in front of Judge Gross and with everybody's schedule. That was a date, how we came up with that date. All right, so thank you, Mr. Lynch, for adding that. I didn't want your you're absolutely right. We just didn't pick some date way in the future for randomly. There was a little bit of a method to how that date was picked. So, all right. So, Ms. Brown, is there anything, before we get to Mr. Lynch's motion, is there anything else on behalf of the people?
No, Your Honor.
Okay, and Mr. Lynch, again, just prior to your bond motion, is there anything else with regard to either discovery or scheduling or anything of that nature?
No, Your Honor.
All right, and I want you to know as well, Mr. Shaw, that this is scheduled for an in-person examination. So if you remain in custody, you would be brought to the courthouse for that hearing. Okay?
Yes, sir.
Okay. All right, Mr. Lynch, you want to proceed with your motion?
I do, Judge, and I want to thank the court for acknowledging that you have received it. I did fax it to the court. I did email it to the court reporter, Ms. Jefferson. I'm assuming Ms. Brown has seen it. I did send it to her superior, Mr. Keast. I'm assuming he forwarded it to you as well. Judge, at the risk of repeating myself, I still think it's important to do. In this case, my client's charged with one count of assault with intent to commit great bodily harm less than murder. It's a felony punishable by up to 10 years in prison. Obviously, this is a case arising out of an alleged situation that happened in Pontiac one night outside on the streets. It is our position, obviously, the prosecution's is different, that the case and the strength of the case is different, obviously, than we see it. But there's no reason to go into that. I mean, that's why we have an exam. I understand that. But I'm asking the court to look at this. My client's bond is set at $250,000 cash shirt. My guess is that at the time that the magistrate set that, they probably saw that the co-defendant was charged, and I call him a co-defendant because he's on the same complaint, with open murder. Obviously, if my client had been charged with something like that, I understand that. But my client's not on probation. He is not on parole. I don't have a full lien history as we're not provided that, but there's a very good chance, depending on his history, that an assault GBH can be an offense that, quite frankly, is with a straddle cell probation eligible. I'm not saying that he is. I'm just saying that that possibility exists. He is employed at Fair Landscaping. He has a newborn child. The bigger issue, too, Judge, is that he's in Section 8 housing, and he's about to lose that housing. And if he does not get back in that, he will then be kicked off the Section 8 list going forward. So you're stuck in a situation, or he's in a situation where it's our position that he's innocent until proven guilty. Based on the original statements that may have come in when the magistrate set the bond, and in some consideration of a murder, his bond is so high. If the Oakland County Prosecutor's Office thought that he was involved in that murder or somehow led to it, we know that they would have most likely charged that. Now, I know that there's going to be an exam. I know that Ms. Brown and I obviously see it differently, and that's the benefit of, or that's the reality of an adversarial situation. But I'm asking the court to just look at this and what the bond is. And I know the easy thing is to say, well, Mr. Lynch, there's been no exam, there's been no testimony. How do we show that there's an abuse of discretion? I think that we can at least surmise that based on this amount of bond, on a man not on probation, not on parole, to be set this high, is that it was set in conjunction with the co-defendant, who's the one charged with the open murder. I'm not asking for a personal bond. I don't think that would be reasonable. I'm asking the court just for a $10,000, 10% bond, so that he can return and not lose his housing, continue with his job. He lives locally in Pontiac. He has his whole life. He was cooperative with the police when they brought him in. He sat there. I watched the video. It's about a 4-hour long video, although they only really interviewed him for about 40 minutes. So I would ask the court to amend the bond to the $10,000, 10%.
All right, Ms. Brown?
Your Honor, I did get the opportunity to review the motion this morning. If I may just address a couple of issues. First, with respect to the magistrate setting the bond consistent with what the co-defendant's charges were, being open murder, Terrence Moore his bond is no bond. He was denied bond. when we're just focusing on Mr. Shaw, I think the magistrate did. I don't believe there was abuse of discretion. I think they looked at Mr. Shaw's criminal history and the facts and circumstances of this case, independent of Mr. Moore. One of the issues I bring to the court's attention is when we're talking about the defendant's prior criminal history, there is prior assaultive history in this case. We have an aggravated assault from April of 2018. There is a juvenile BNE, some uttering and publishings. But I think the main ones that I'm referencing are the aggravated assault, as well as another charge where he had a CCW, possession of a short barrel rifle, and a felonious assault charge. So we have someone that has a prior assaultive history, and we're looking at this case and he's being charged with assault with intent to do great bodily harm. When we're looking at defense counsel's motion, I appreciate that he indicated on the record that we have discussed this case. And in paragraph 5, he talks about there's no allegation that my client was involved with the alleged homicide. I obviously there will be an exam in this case, both requested by the people and the defense. We have discussed the concerns that the people have with respect to Mr. Shaw being charged with open murder. I believe based on the circumstances at the conclusion of the preliminary exam, that is a possibility. We did discuss that. I'm not indicating at this point I'm increasing the charges, but what we have is a fight. We know that Mr. Moore, Mr. Shaw were both involved at that fight. We know Charles Williams is now deceased and he died of multiple stab wounds. What we also know is that there was a search warrant done of Mr. Shaw's home. They entered the home. In that bathtub, there were items that were collected that appeared to be soaked in bleach and had the officers described in the police report as being blood-stained. Now, taking all of that into consideration, here we are. When you say an assault GBH, this isn't just one incident where it's like, okay, someone's being hit with something over the head and, that's that. Here we have a fight where the defendant was clearly a part of that. And I understand that as a question of fact for a trier of fact, whatever position he makes. But I think when you take all of those facts and circumstances, when you're looking at the safety of the community, the seriousness of the offense, someone's prior criminal history, I think the bond is set as appropriate. And I think the magistrate did not abuse their discretion. I think they considered Mr. Shaw independent of Mr. Moore.
Since it's my motion, can I have the last word?
Oh, yeah. I have a couple questions for you too, Mr. Lynch, before you get your last word. Can I ask you a couple questions?
Sure.
All right. I do have the benefit of a report from pretrial services, and this is one that was done at the time that the bond was set. So it has not been updated, but the pretrial services investigator indicated there were a couple of outstanding warrants. One was out of Ypsilanti District Court, and that was just for a failure to appear just on a traffic matter. So I'm not looking at that real closely, but there was another one out of the 52-3, and I believe he was, I think he may have been arraigned on that warrant. Are you aware of that, Mr. Lynch? Because that warrant was, that bond, I think was, they may have a typo in here. I can't tell if it was 25,000 cash surety or 10% or 2,500 cash surety or 10%. Are you familiar with that?
I am not, Judge. Unfortunately, we are not provided those pretrial services reports for whatever reason.
I know. If you were here in person, I'd have provided it. It's just where they put their comma. I can't tell where they put it, but
We can ask
Don't mind me
Mr.
asking
Shaw.
your client, was he arraigned by the 52-3? And I don't know what that case would have been. So does he?
He can answer that question. Mr. Shaw, have you
I
been
think
arraigned by
that
the?
might have also been, maybe it was 2,500 as surety. But I think that was, would have been maybe Judge Asadorian's case. Also just, maybe driving with a suspended license and narcotics paraphernalia. Are you familiar with that, sir?
Yes, sir. I was sentenced to 30 days on the driving while suspended, and the drug paraphernalia was dismissed.
Oh, okay. So you've already done the time on that case then.
Yes, sir.
Okay. All right. That was just a question I had. So that matter has been resolved. All right. So go ahead, Mr. Lynch.
Judge, the only thing I wanted to indicate, and it's nice to kind of for once get the last word. We don't get that very often. Not that I have I understand the statements that Ms. Brown made, but one thing she left out in this case, and not trying to blame a victim here, but the reports also support and suggest that Mr. William, the alleged victim, was the aggressor here, and that he had struck more than one individual with a metal pipe as well. So when she says that it's a fight and that it's not just a singular punch, that may be, and we'll have the testimony of the individuals that were present. But it appears that it's a situation that was started by the complainant or the alleged victim here.
Okay. All right. I'm going to ask Ms. Brown if she has anything else, but I'm still going to give you the last word, Mr. Lynch.
And Your Honor, and the only thing I would indicate is this. That's one of the reasons we're running a preliminary exam in this case based on the circumstances. Counsel and I agree to disagree on certain aspects. I think the main thing that we can't ignore is there was a fight. Mr. Shaw played a role in that, and someone is now deceased. I think that the bond is appropriate.
Okay. And Mr. Lynch, I got one other question for you, and then I might have to ask your client, and then you still get the last word, other than my last word of making a decision. So my question to you and your client, there also appears to be in the pre-sentence, the pretrial services report. And if you were here in court, I'd let you look at it, but you're not. It does appear that there was a referral to OCHN, Oakland County Health Network, to look at some mental health issues. So I don't know if your client has been contacted by the OCHN person at the jail and whether he's had any meetings with them, or whether they've prescribed any medication, or whether he has met with someone. Do you know that, Mr. Lynch, or would you allow me to ask your client?
Mr. Shaw can answer that question.
All right.
Yes, I've met with OCHN. I'm currently on my medication that I actually haven't been on in a while. Doing actually really great. Not suffering from any of the issues that I normally have. And I plan on continuing doing everything. I'm healthy, gaining weight.
Okay. So the person from OCHN that you met with at OCJ, if you were to make bond, you would be able to contact OCHN to continue as an outpatient?
Yes, sir. I have all of the information in my cell. I also have a CNS worker, so I plan on doing all of my medication and all of everything if I was to make bond.
All right. Okay, Mr. Lynch, go ahead. Last
Judge,
word.
I don't want to keep going around and around. I've had the pleasure of knowing Ms. Brown for several years. We've actually tried a murder case before. I think that there's a fair amount of professional mutual respect between us, and obviously we see things differently. I agree with her that there's a fight. I think the question comes down to the exam is who actually started the fight. And the question will also be my client's overall involvement in this alleged fight, or whether he was assisting somebody else or coming to the aid of somebody else. So that's the purpose of an exam. I think Ms. Brown and I would both agree on that. It's just our belief that this bond, as set, and for the reasons I've laid out, is extreme and excessive, and we're asking for the bond modification.
All right. Well, what I have by way of, thank you both of you, and Mr. Shaw, thanks for filling me in too on some of that. Mr. Shaw does have a criminal history, and I have the benefit of this through the report from Oakland County Pretrial Services. He has somewhat of a history of a failure to appear on some matters, mainly some traffic matters. He also, and Ms. Brown referenced this, the matter with a weapon, the felonious assault and felony firearm, those were nollie-prossed by the prosecutor in the 30th Circuit Court, if that's the case you're referring to, in 2009. But there was a conviction on just carrying a concealed weapon, that being I think a shotgun of some short-barreled shotgun, in which he was sentenced to prison, and then he was paroled. He got 1 year, 11 months to 5 years. I'm not sure when he was placed on parole, but he was discharged from parole in 2016. So during his parole period, he appeared to be fine. And then there was a matter that appears out of this court where it started out an assaultive offense. So he's had some others, but maybe it could have been a history of some mental health issues when he may not have been properly medicated, which he appears to be on right now. And then there was a warrant sought in May of this year out of Auburn Hills, but the prosecutor denied that warrant against him. So Pretrial Services does recommend, and I would agree with them, that some sort of cash or surety bond is warranted. I think the issue here is just the amount. So I think, again, some amount of bond is warranted. But I don't think it needs to be the $250,000 cash surety. So I'm going to grant the prosecutor's motion, but I'm going to set the bond in the amount of a $25,000 cash surety or 10%. And the condition on the bond, Mr. Shaw, is the same. You're not to possess any dangerous weapons, so no guns, no knives, nothing else that could be considered a dangerous weapon, and you're not to have any contact with the co-defendant in this case, that being Mr. Moore. You understand?
Yes, sir.
All right.
Your Honor, if the court is inclined to grant the defense motion, may I ask the court to impose a GPS tether?
Stupid ass.
Well, I don't know if, just confine him to his, I'm not sure about work or his house.
Well, yeah,
It's
this
not
is,
like he's gonna be in contact with the, he's not gonna be in contact with, the victim's deceased.
Right.
He's not gonna be in contact with the, co-defendant, because the co-defendant, personal contact, because the co-defendant is incarcerated. So those are the two people that he really shouldn't have contact with. So
in
you
addition, what
just
I want
want
the
it
court,
so for flight purposes? Is that your reason?
Your Honor, what I want the court to understand is when counsel and I are referencing a fight, this is a fight in Pontiac. Witnesses in this case are people, including some are minors, that have provided statements with respect to things that they had observed. Think based on the safety of the community, understanding that we already have a situation where it appears, and again, I understand it's alleging that Mr. Shaw, there's bleach in the house, where if in a bathtub with bloody clothes. I mean, we do have that concern. So I have concerns that he's going to reach out to these people that are civilian witnesses that are to testify at the preliminary exam. And certainly, I think it kind of goes to the safety of that community. I mean, it's a small, in that area, it's a small community, and those are all valid, I think valid concerns.
Well, I'm gonna make as a condition of his bond that he continue treatment with OCHN and take the medication as prescribed.
Face turned red in the bitch.
She mad as hell.
I don't have a list of all your witnesses. Again, if they're minors, we're live via YouTube. I don't want to start putting people's names out there. I don't even know if he knows who all these witnesses are going to be.
Exactly.
So you could be just putting in his head, potential people that he's totally unaware of.
Right.
So I just don't, I will instruct you, Mr. Shaw, that you're not to discuss this case with anyone other than your attorney, and you're not to, engage in any behavior with anyone in the neighborhood. If they get reference to that, the police are gonna come out, the deputy sheriffs will just pick you up on a bond violation.
All right. Stupid
Yes,
ass
sir.
bitch.
Okay?
And Your Honor, the witnesses' names are listed on the front of the complaint, which obviously counsel has. I think it's very important because we have not had an exam yet. I have concerns
That's the
regarding
reason why
witness
so many
tampering.
innocent
So
people
I think it's
locked up.
important that the court instructs
Bitches like
Mr.
that.
Shaw not to have any contact with any witnesses in this case.
And that's fair, Judge, and we've made it crystal clear to my client. And if he, quite frankly, has any contact with him, he does so at his own peril. I would hope that if he
Well,
does
I'll
post his
add them. I mean, you've got, you're not,
He
half
has
the
discovery,
witnesses
Judge. He has
witnesses are either doctors, crime lab people,
Exactly.
people
Like
regarding
on your
scene
list.
processing, a whole slew of detectives and deputies. You're just talking about 1, 2, 3, 4, 5, what look to be citizen people.
Yes, I'm not worried about officers.
Okay.
My issue with
So
him
I'm
about,
happy with saying no contact to any of those. They were not listed as the, on the original. None of those were listed as no contact at the
Yeah,
time of the original
yeah.
bond, Ms. Brown.
I'm glad we
I-
caught
It's
this
not
shit.
done at the time.
that's why I'm just, okay,
I'm just telling you. So, Mr. Lynch, you have no objection to that? I just don't necessarily want to put their names out on YouTube.
I
Right.
have no objection to that at this point in time, Judge.
Okay, so there are 6 people, sir, who are listed as witnesses, and they will be on your new bond, and Mr. Lynch can go over those with you because he knows who they are, right, Mr. Lynch?
Yes.
They're the ones, you're looking at the list where we've got the doctor, so the 6 names above that, he's not to have any contact with, and I will have those on as bond conditions. So no contact means just that, no contact. You're not to see them in person, telephone them, email them, text message them. write them letters, go on their Facebook pages, no tweets, Snapchats, Instagrams. Any way people communicate with people, you just totally stay away from those 6 people, okay? All right, any questions?
Judge, will the court prepare an order, or should I send over an order for your signature?
I don't know how they work it here. I guess if you could email that to Ms. Jefferson, okay?
I'll prepare that now, Ms. Brown. I'll send it to you first for your authority. I'll say approved as to form only.
Thank you.
All right, anything else, Ms. Brown?
Nothing further from the people.
No, Judge.
Lynch? No, okay. All right, you guys are good to go. And make sure you follow those bond conditions, sir.
Yes, sir.
All right. Have a nice holiday.
You too.